Hello everyone. ADR, Alternative Dispute Resolution, refer to non-courtroom ways to resolve legal dispute. ADR include mediation, arbitration, and negotiation. These methods are less formal, stressful, and private than court. ADR offers save time and money. Each party is important in mediation. Mediation, arbitration, conciliation, negotiation, and transaction are ADR methods. Let's talk about arbitration. An arbitrator hears both sides' agreement and evidence and make a binding decision in an arbitration proceeding. Arbitration has looser evidentiary rules than trials. Binding arbitration parties agree that the arbitrator's decision is final, cannot be appealed. Non-binding arbitration parties may request a trial if they disagree with the arbitrator's decision. Then, mediation involves a neutral third party, helping the parties to a compromise. The mediators help parties communicate, not decide the case. Mediation may resolve family, neighborhood, and business disputes. Next, negotiation resolve most conflict. Negotiation is usually tried before arbitration or mediation. Negotiating parties can meet face to face. This method put dispute resolution in the hands of the parties, which is main merit. Did you know Malaysian most popular ADR method include arbitration, construction, adjudication, and mediation?
Hello everyone. I would like to discuss the various types of alternative dispute resolution method. The first idea will be explored is negotiation. Negotiation is a process of dialogue between parties to dispute and to find a mutual acceptable resolution. It can occur directly between the party or involve in an impartial third party, such as mediator and facilitator. Negotiation allows parties to actively participate in settling their dispute, avoiding the expense and time constraint of legal process. Additionally, negotiation is typically quicker and less expensive than going to court. There are two major types of negotiation: distributive and integrative. Distributive negotiation focuses on maximizing one party gains at the expense of the others, while integrative negotiation involves both parties working together toward a mutual beneficial solution. Moving on to mediation, which is another widely used ADL method. Mediation involves the inclusion of neutral third party, called mediator, to assist party in reaching a consensus agreement. It is a voluntary and confidential process that promotes effective communication, negotiation, and the consideration of each other's interests. Mediation is often used in various contexts, including business, civil lawsuit, and divorce. Its effectiveness is rooted in the party willingness to work together and their ability to craft creative solutions, which can foster better long-term relationships. There are two common forms of mediation: facilitative and evaluative. Facilitative mediation focuses on helping parties communicate effectively and develop a constructive relationship to reach a mutual acceptable solution. Evaluative mediation involves the mediator actively providing feedback and suggestions to guide the parties toward a resolution. Lastly, let's explore arbitration as an alternative dispute resolution method. Arbitration involves resolve dispute through the appointment of an impartial arbitrator or panel who render the binding decision. The arbitrator uses their expertise to evaluate the fact and identify the legal issue involved. The decision rendered by the arbitrator is final and binding on both parties. Arbitration is often preferred for its speed and cost effectiveness compared to traditional litigation. However, it may have a limitation such as limited avenue for appeal and fewer opportunities for discovery and evidence collection. Arbitration can be classified into binding and non-binding arbitration. In binding arbitration, the decision of the arbitrator is legally enforceable and there are limited grounds for appeal. In non-binding arbitration, the decision is advisory and not enforceable, allowing the party to explore other dispute resolution options if desired.
Firstly, we will talk about advantages of negotiation. Negotiation can build better relationship. This is because different opinion between those parties can reach one word with win-win situation whenever they point out what they want and what they don't want according to their interest in the business relationship. Second advantages is lasting and quality solution. Third advantages is win-win situation. And lastly, lower cost. We can get lower cost whenever we do traditional way of discussion. As we know, negotiation just involve two parties, which is buyers and sellers. Next is advantages of mediation. Mediation can be affordable This is because mediation is less than typical time and financial expenses of litigating a disagreement. Usually the charge for the mediator is less than lawyer charge. Second is mediator helps to reach conclusion. And lastly, confidential. This is because in discussion time, we will just have buyers, sellers, and mediator.
Next is the challenge of alternative dispute resolution. In negotiation, there are three challenges, which are power imbalance, lack of legal structure, and communication challenges. Firstly, power imbalance. The difficulty in negotiating when there is a significant power disparity, with the stronger party dictating terms and leaving the weaker party at the disadvantage. Secondly, lack of legal structure. Absence of formal legal enforcement in negotiation, which can make it challenging to ensure compliance and settle issue efficiently. Lastly, communication challenges. Obstacles such as language barrier, culture differences, and emotional tension that hinder effective communication, potentially leading to misunderstanding and difficulties in finding mutually satisfactory resolution. In mediation, there are also some challenges, which are firstly, unwillingness to participate. It is success depend on both parties' willingness to actively engage and collaborate. If one party is hesitant or combative, the mediation process may fail.
Example of
Secondly,
cases that have
power
happened
dynamic and
in
imbalance.
ADR.
Power
The
imbalance can
first one is
affect
on
fairness, especially when one party
arbitration.
has more influence or
So one of the
control.
cases that have happened
Mediators
recently is
need to
Kindred
address
Nursing
these
Centers Limited
dynamics
Partnership
to
versus Clark
ensure
that
equal
occurs in 2017.
participations.
In these
Lastly,
cases, Olive
failure
Clark
to
and
reach
Joe Wellman
agreement.
resided in
Despite
Fullerton
mediation
Shelter Care
effort,
owned by
parties may
Kindred
be
Nursing
unable
Centers
to reach
in
a
Winchester,
mutual
NY.
acceptable
Prior to
agreement
facility arrival, they
due to
nominated family reps
significant
with significant bargaining authority.
disagreements in
Janice
positions,
Clark and Beverly Wellner,
interests,
as
or value.
representatives, signed an
Additional tactics may
arbitration
be need
agreement
to
for
be
Olive and Joe's case,
help find
resolving
common
any
ground.
potential issues.
In
Olive and Joe died in
arbitration, there are
2009, and
several
Janice and
challenges.
Beverly sued
Firstly,
Kindred Nursing for
limited
their loved one's death due
applicability,
to the nursing
not
home
suitable
errors.
for all
They
cases,
wanted compensation for
especially
harm
those
caused,
involving
and
complex
Kindred Nursing
legal
proposed
issue,
arbitration
public
to
policy
settle the
concern, or
dispute.
matter of
They
great
agreed and
public
signed some papers
interest.
for this. The
Secondly,
court
lack
dismissed
of
and
appeal
opted
option.
for arbitration.
Finality of the
However, there
arbitrator's
later followed
decision
the
with
same legal
limited
rule set
avenue
in
for
Pin versus
appeal,
Beverly Enterprises
potentially
Incorporation,
limiting
a company
a
named in a
party's right
Kentucky
to a
court ruling found
comprehensive
that a power of
review.
attorney cannot compel an
Lastly,
individual to use
potential
arbitration against their will.
arbitrator
KY's highest
bias,
court
risk
upheld
of
lower court ruling.
partiality or bias, which can
The second
undermine the
case is a
credibility
case
and
on
fairness of the
negotiation
arbitration process.
where Virginia Railway
Institutions
versus
have
System
ethical
Federation number
norm
40 that happened
and
in
vetting processes
1937.
to address this
In
concern.
1927, American workers formed System Federation Number 40. This union was in the AFL. Federation sues Virginia Railway on behalf of workers. In 1934, workers sought train company approval for designated representatives. The group sought aid from the National Mediation Board, formed for train-related legislation. NMB declares Federation the official voice for railway workers after election victory. Union sues Railway in Virginia over lack of communication. Union seeks Railroad Corporation. The Federation cited a 1934 railroad law requiring collaboration with authorized union reps. Railways should communicate with Federation.
railway exempt from the rule. Congress did not intend enforcement. Not possible to force agreement for all. They claim it's illegal to compel them due to the Fifth Amendment. Court orders railway company to consult with the Federation on rules, pay and work. The railway company can't form a troublesome group for the Federation. The Fourth Circuit Court affirmed the lower court's decision and top court to hear the case. Like Michigan USA mediation that happened in 1996 is the example of mediation cases that have happened. During this case, US government debates Lake Michigan water use. Overdrawing water can harm nearby lakes. From 1920 to 1995, the US Supreme Court heard over 4 disputes on this issue. In 1995, a US Supreme Court disagreement occurred. 8 states and US government resolved it collaboratively. They agreed on costs to divide it. Within a year, they aimed to resolve the dispute permanently. 8 states signed an agreement on October 9, 1996. It is in a memorandum of understanding.